Good afternoon to you all, and welcome to this seminar that is hosted by OCAJI. We're very grateful to OCAJI for hosting this program of seminars and inviting us to speak today. Today's session is a joint presentation by HKA and CMS on the topic of dispute avoidance. And in today's session, we're going to look at three main themes. The first theme will be the main causes of claims and disputes in the construction industry. And then we're going to move on to look at some examples of how you can manage dispute-related risk and look at the importance of program management and record keeping in the context of managing these disputes. And we're also going to look at ways of avoiding disputes across the entire project cycle and to look at various ways of minimizing and avoiding disputes from arising. Now, you know, most of you in the construction industry will know that it's almost a fact of life that the construction claims and disputes are commonplace on projects. And claims and disputes simply come with the territory of contracting. The business of contracting is challenging, and claims and disputes are simply part and parcel of contracting. And from really a construction lawyer's perspective, it seems to me that construction projects have the three main ingredients of a dispute, and it seems to be the three main ingredients that we're always contending with are firstly, on such projects, the contractor is working to very tight margins. The contracting business is a competitive business, and there's enormous pressure on you to submit keenly priced tenders with fairly, slim margins. And the second point is construction contracts give rise to high risks. The risks of contracting in the various geographical regions that you often find yourself in are high. You are facing various risks, political risks, military coups, adverse ground conditions, harsh environmental conditions and harsh weather, labour problems and the availability of labour in various locations, difficulties in supplying materials and securing the supply of materials to remote locations, insolvency of your subcontract chain, and so on. There are a myriad number of factors that present themselves in contracting that make it very challenging, and it involves you in running huge risks on these projects. And the third sort of ingredient that leads to disputes is really the fact that the stakes are high. If something goes wrong, if any of these risks materialize on your project, then the losses are very significant, and the project simply cannot absorb these losses, and you are compelled then to pursue a route to negotiating a claim for extra cost or time. So that creates a backdrop of a very sort of fertile ground for disputes. And as I say, it's part and parcel of contracting. And construction is a very sort of unique sector across the globe. Unique in the sense that many jurisdictions, and the UK is just one jurisdiction, have singled out construction as requiring its own dispute resolution procedure. That's quite extraordinary in many senses, because no other sector has been singled out by governments in that way. So in the UK, for example, we have statutory adjudication, which is a compulsory statutory process to resolve disputes on a fast-track process. But that's just an example of the fact that it's recognized, across the globe, that the construction sector is unique and is contentious and in a sense adversarial. So, we are all, all of us working in this industry are sort of plagued with dealing with claims and resolving them. So the challenge for us all really, and the focus of today is, well, given that backdrop, how do you actually avoid disputes arising? And if they do arise, how do you effectively manage those disputes and resolve them and try your best to avoid being drawn into a protracted, expensive, formal procedure like an international arbitration? So we're going to focus today's discussion on how one can go about eliminating the risk of disputes and managing them, and importantly, if you cannot resolve them, well, how do you maximize your position so that you can precipitate a settlement and improve your negotiation position and strengthen your position for an arbitration if you're forced down that route. So the format for today is that we're going to have two presentations from Benjamin Highfield and Sarah Grenfell, and each presentation will last approximately 20 to 25 minutes. And we will then have 30 minutes approximately for a question and answer session. So can I encourage you all to use the chat function, which you'll find on the right hand of your screen, to send in any questions throughout the session, and I will pick them up at the end of the presentations when we move on to the panel discussion. And the intention is that this session will last a total of an hour and a half, so we will wind up the seminar at 5:30 JST time. So in your pack, you have profiles of all our panelists, but let me briefly introduce them before we move on to the presentations. So our first speaker is Benjamin Highfield. Ben is a partner and claims specialist at HKA, and Ben heads up the Middle East and Asia practice for HKA. He has wide-ranging experience across many major projects, from the construction of buildings to complex process engineering plants in the energy sector. Among Ben's many talents, he's also a chartered civil engineer, but his primary focus is quantum and delay analysis in the context of resolving high value and complex claims. Our second speaker is Sarah Grenfell. Sarah is a partner in the international law firm of CMS. Sarah is an international construction lawyer whose projects span the globe. And prior to COVID, Sarah was a frequent visitor to Japan and has acted for a number of major Japanese corporations on their overseas projects. While Sarah is both an English and Australian law practitioner, she also is a lead partner on other arbitrations governed by laws other than England and Australia. And I'm very pleased and honoured to introduce our guest panellist, Mr. Kenichi Kunikane-san. Mr. Kunikane-san is the Chief Manager of Contracts at Taisei Corporation. And Taisei Corporation needs no introduction, and as all of you know, it's a global construction company. Kunikane-san is no stranger, therefore, to disputes and dispute resolution. a field in which he has accumulated hands-on experience for over 20 years now. And he has held both legal and commercial positions at Taisei Corporation. Kunikane-san also sits as an adjudicator on dispute review boards, which he has done so for the past 10 years at least. So we're very grateful to Kunikane-san for taking time out of his busy schedule and joining our panel this afternoon. So we'll now press on with our presentations, and I'll now hand over to Ben to make the first presentation.
Thank you, Terry. Thank you for that very generous introduction. It's a great pleasure for me to present today in collaboration with the Overseas Construction Association of Japan. I recall I gave my first seminar with OCAJI way back in 2014 in Tokyo. And since that time, I've presented on 8 occasions to OCAJI members. My first ever trip to Japan was in fact in 2013, and actually the purpose of that trip back in 2013 was to visit Taisei Corporation, and I gave a seminar in Taisei Corporation's offices way back in 2013. So it's a great pleasure to be sharing a stage 8 years later with Kunikane-san. And finally, it's a great pleasure to be sharing a stage with both Terry and Sarah, both reputed lawyers, and I'm delighted to be with them here today. As Terry already mentioned, I'm going to be presenting for about 25 minutes, and then I'll be handing over to Sarah. The subject matter of my presentation is claims and dispute management, lessons learned from a COVID year. But before I start, we're going to kick off with a quick poll. Should delay penalties be waived under any and all circumstances? If you read that as any and all circumstances during COVID. So should delay penalties be waived under any and all circumstances? And the purpose of this question is for projects that are delayed by COVID, but are also delayed by other matters. If you could click either yes or no, and we can judge what the audience thinks of this matter, and I'll give you 20 seconds. Okay, Crystal, let's hear the results. Should delay penalties be waived? Oh, wow. So that's a very, very interesting answer. Before I got this result, my assumption would be that most people would say yes. But in fact, 67% of this audience is saying that they should not be waived under any circumstances. That leads me to think that we've got some owners on this seminar. It's an interesting question, of course. If you look at certain countries such as Singapore, laws have been put in place in relation to liquidated damages. And I think what the audience is saying here is that the owner should still be entitled to deduct liquidated damages in circumstances where delay is arising and there's also a COVID pandemic. Very, very interesting poll result and certainly food for thought. Let's move on to my slides. Okay, I think I've already been introduced. With HKA, I specialize in complex disputes, both delay and quantum disputes and contracts, complex contractual matters. It's taken me all over the world. I've negotiated major settlements with major EPC owners, and I've been in this industry for nearly 20 years. Just a little bit about HKA. We're an award-winning business. We're a 40-plus-year-old business. We're independently recognized as the #1 provider of construction experts by Who's Who Legal, and we were awarded Construction Expert Witness Firm of the Year, both in 2018 and 2020. We're also recognized by Global Arbitration Review, and we were recognized in the NEC Awards, amongst other things. The Academy of Experts recognizes HKA, and the current chairman of the Academy of Experts is a HKA employee. On the agenda today, I'm going to look at some data that has arisen from HKA's Crux Insight report. I'm going to talk a bit about claims avoidance strategy, common dispute types, and contract remedies, and then about the technical matters of delay to progress and loss of productivity, and some tips in relation to that. And then I'm going to talk about the importance of records. So the Crux Insight report is a report that was started by HKA back in 2017. It collects real-life data from projects where HKA is appointed as the expert. Those projects, of course, have been made anonymous so that clients' confidentiality is protected. But we look at the causes of delay, causes of financial loss across over 4,000 causes of claims and disputes. And we use this data to try and understand what is the cause of different disputes in different parts of the world. In relation to that report, we have focused on various regions in the world, and in respect of Asia, the chart here shows the top causes of disputes and loss and expense in Asia. And just picking out a few of these, unsurprisingly, the #1 cause of disputes is change in scope. And I think it would be fair to say the perceived change in scope, where in most cases a contractor considers its scope has been changed and the employer doesn't agree. A change in scope are not just obvious things like additional works, but it could be things such as change in sequence of work, delay to the commencement of work, change in work methodology. Other very significant causes of disputes: access to site, restricted access to site or late access to site. A big one is contract management and administration failure, failure to administer the procedures in the contract. Design information issued late is a huge cause of delay in the industry in Asia. Getting confirmation and approvals on design, and the knock-on on procurement and construction works. So there are a number of key causes of delay, and in respect of the projects we've been involved with, typically the extension of time is 63% of the planned duration. So you're talking about an overrun well near excess of the original duration of the project, and then the dispute value can be 30% of the overall planned project cost. So these are huge numbers. Just focusing on Asia, we've broken it down into Central Asia, East Asia, and South Asia. In HKA's arrangement, we've placed Japan within Central Asia. Appreciate that it's more Northern Asia, but it sits within the Central Asia study. And essentially in Japan, or certainly with Japanese contractors, the biggest cause of disputes is incorrect design. Now, incorrect design can mean at feed stage, so feed design provided by the employer, but it also includes designs presented by the contractor as part of its EPC obligation. The next biggest one is late approvals, so approvals from the employer or the employer's representatives, and so on and so forth. So these are the key issues that are affecting Japanese contractors in the Asia market. So just moving on to claims avoidance and management strategy. So these issues that we've seen, what do they translate into? Well, they translate into common dispute types. And those dispute types include scope changes. And these are principally changes in engineering design and specifications, but they can also be concept changes. And concept is something that is quite difficult to contract to. And a concept change, for example, can be an architectural change. So it may be that a Japanese contractor has entered into an agreement to build an airport, but the architectural solution is not clear in the tender documents. It's to be developed. And such a circumstance leads to disputes. Changing construction methodology, often overlooked. It may be that a contractor has bid a project based on a top-down method of working and they have to move to a bottom-up. They may have planned to use reinforced cast in situ concrete, but the employer's view is that precast concrete is preferred. And on the basis of preferences of the employer and the engineer can be a big issue. Particularly with EPC contracts where a solution is presented to the employer. And although that's a compliant solution, the employer doesn't like it and prefers a different solution. Change to the scheduled completion date. Interestingly, we've seen a lot of COVID cases where the employer has extended the completion date and freely given an extension of time, but is very, very reluctant to provide any kind of costs associated with that. It could be a change in the start date, and more frequently, in particular in the last 12 months, we've seen a big amount of de-scoping of work. I'm involved in both rail and airport matters with Japanese contractors. In both instances arising out of COVID, there's a de-scoping of work. Which of course can cause a dispute over the valuation of such. So what remedies do you have available to you in the instance that you're a contractor? Well, you have an extension of time, and an extension of time is essentially protection against liquidated damages. These are the damages that come with delay, and relief from those is enshrined in most construction contracts. You have the right to claim for prolongation costs. These are the costs associated directly with delay, and those prolongation costs can be recovered for periods of delay which are at the risk of the employer, but they may not apply under circumstances where there is both employer and contractor delay. There are disruption costs. Disruption is essentially a loss of productivity, and we've seen a rise in disruption claims in the last 12 months of about 50%. And the reason for that is quite simply the disruption that's been caused by COVID. And of course, COVID has caused a lack of manpower, site inspectors, it's caused problems with procurement so that the works are not being progressed in the manner in which the client considered it would be progressed. So disruption has been a big issue in 2020, and we expect it to be a big issue in 2021. Another quite surprising element which has arisen out of COVID is material price escalation. For the most part, most commentators 6 months ago expected material prices to reduce because of a lack of demand, but because of interruption in supply chain and a recent rise in oil prices, we've actually found that in certain regions such as Saudi Arabia and in Vietnam, material prices have actually escalated arising out of COVID, which has caused a dispute and associated claims. And then generally there's disputed variations. So that's something that one party considers as a clear change to the scope and should be a variation which has profit attached to it, but a claim arises out of that. So associated with these claims, there are contract remedies. Now, Sarah is going to talk about that later, but modern standard forms of contract contain remedies to compensate contractors for the above. I think what's really important, remedies are designed to deal with the problem at the time it occurs, and the contractor is required to comply with a strict procedure. And I think importantly, for a number of my Japanese clients in particular, they're very, very reluctant to raise notices and submit claims. And I think that really stems from a cultural environment where the environment in Japan is if you do a job and you do it well, you deliver a high quality product, then at the end of a project, claims and cost overruns can be discussed. But the reality is, certainly in the international space, if you fail to comply with the procedures in your contract, then that often serves as a condition precedent, which means that you lose the right to claim something that you would otherwise be entitled to. So it's very, very important that the audience recognizes that although it's uncomfortable and you don't enjoy raising notices and you don't enjoy submitting claims from a cultural perspective, if you don't do so, it creates a huge risk for you. The employer has a duty to make a determination against the claims that you submit. A failure to do so provides the contractor with various options. But interestingly, any failure by an employer or its representatives usually does not serve as a condition precedent. So the employer or its representative does not usually waive its rights if it does not respond, whereas a contractor often waives its rights if it does not comply with the procedures in its contract. So just talking to delay to progress. Progress and delays are dealt quite simply with by the use of an extension of time clause. And every contract has one. And in the event that a contract does not have one, typically a contractor has the right to an extension of time automatically. But in 99% of cases now, construction contracts will have an extension of time clause. And the purpose of this clause is not to be ignored, but it is a mechanism that both the employer and the contractor to use. It keeps alive the employer's right to liquidated damages. And as we've seen from the poll, the audience that considers that even in a COVID year, that right is sacrosanct. It gives the contractor relief from liquidated damages for excusable delay. Benefits of the EOT clause is that in most locations, the employer does not have to prove loss. So the liquidated damage rate is pre-agreed, and the contractor has some certainty. And importantly, in most instances, the contractor has a limit on liability. Typically, that would be 10% of the contract value, but it could be more or less than that. Now, for the audience, for the benefit of the audience, in instances where you believe you have a right to an extension of time, there's a simple procedure that one must follow. First of all, you have to identify the event which gives rise to change causing a delay. So something has to happen. It's not good enough just to say, I'd love an extension of time and apply for an extension of time, quite simply because the project is late. You need an event. And you need to establish that there's liability for the event. And that liability comes under the contract. So you have to examine the contractual provisions entitling the contract to an extension of time. And I think what's really important during a COVID year is that you don't just make the assumption that COVID is responsible for the delay. A number of my clients have come to me and said they've been terribly affected by COVID and they'd like an extension of time. But actually, when you inspect the records and you inspect the progress and you inspect the events that happen, you often realize that the driving delay is something that is unrelated to COVID. So whatever you do, don't make an assumption about what the driving or the critical delay to your project is. You must analyze the delay by way of contemporaneous records and your program and its updates. So it's very, very important that you don't make an assumption of what is delaying your project. You must do it by analysis only. So, and the purpose of the analysis is to prove something that we call in the industry cause and effect. So successful claims must demonstrate the link between the breach, which is the cause of the delay, to demonstrate the cause and effect. A story should be prepared based on the facts describing the effects of the event upon the works. An interesting example might be a lack of access to site on the one hand, and failure by the contractor to mobilize its subcontractor on the other hand. It's only by analysis of the facts that you might be able to determine whether it is lack of access to site or delayed mobilization, which has caused a critical delay to a project. And the only way you can do so is by a delay analysis. Now, it can be a simple delay analysis or it can be a complex one, but it's important to establish cause and effect by way of delay analysis. And whatever you do, don't just make the statement, the project is late because of lack of access to site, because it's an unproven statement. You have to make the statement in a statement of claim and then provide substantiation by way of documentary evidence. And when we say documentary evidence, we mean primary documentary evidence, which I'll talk about just shortly. So just talking to another element of loss, I'm not going to talk about all elements of loss in this presentation, but I'm going to talk about loss of productivity. And the reason why I'm going to focus on this is quite simply because we're in a COVID year. And in a COVID year, we have elements such as lack of ability of labor to make it to site, lack of site inspectors, inability for plant and equipment to move from one place to another. And it can be something as simple as social distancing, restrictions on team sizes, restrictions on the process of individuals entering to site, testing of individuals, quarantining of individuals. All of this has caused a huge impact on productivity of labor on site. But what is productivity? Well, productivity is the rate at which work operation is performed. It's normally measured as a production per unit of effort or output divided by input. Production can be measured as input divided by output. So what does does that mean? Well, you can measure productivity in various different units. As long as it's measurable, you can get productivity from it. It can be a measure of volume, such as cubic meters of concrete placed. It could be a measure of area, which would be meters squared of formwork. It could be a linear measurement, meters of measurement, units assembled. And typically the inputs would be expressed as effort put in, and it's usually based on hours or shifts or days as an input, as a labor input or an equipment input. So just to give a very quick example, for example, if you have 48 cubic meters of concrete being placed by a man crew in an 8-hour day, but let's say that crew could only place 40 cubic meters of concrete, then you essentially have an efficiency of 83% and an inefficiency of 17%. Now, this is really important because when you're pricing your contract, when you're pricing the works, you're doing it on the basis of an efficiency of 100%. So every percentage of efficiency loss you get is a loss on profit. And you can imagine that your profit may only be 5% of the contract value. And so you can see the importance of labor and efficiency on making a profit on the works. So just to finish with from me, I think it's something that is often mentioned in seminars such as this. I know Sarah's going to touch on it as well. But from the perspective of HKA, and HKA is an organization that provides technical services to prove your case. It's 100% of what we do. We do technical analysis. And from the 20 years of experience I have, the cases that win are the ones that have good records, and the cases that lose are the ones that don't have good records. He who asserts must prove, and that's a fundamental concept. And so one must keep contemporaneous evidence supporting a party's assertion that the event occurred and how it affected the timing, duration, progress of the works. In short, you need records to support your assertions. Now, records do not mean Excel spreadsheets. They do not mean Word documents that you've written. I'm talking about primary records. I'm talking about photographs. I'm talking about daily reports, daily sign-off sheets. These are primary records that come from the source of the activity that's being undertaken, not secondary records that are generated later and after the fact. And just to cite an example on the importance of records, I think the most famous clause of any contract that's used currently in the international space is clause 20.1 of the FIDIC suite of books. It changes slightly from contract to contract, but it's quite clear the contract shall keep such contemporaneous records as may be necessary to substantiate any claim, either on site or at any other location acceptable to the engineer. And it's not only enshrined in the contract, but it's often enshrined in local law, health and safety regulations and otherwise. And it's important to control the progress of the works. If you don't keep records, then there's no way of actually controlling the progress of the works. And the records that should be kept to build as complete a picture as possible of how it was intended to undertake the project. And then the next step is to identify what happened, where, when, and why. And I think a really important point to remember and to recognize about records, it's not just about as-built records, about what is being built. The first thing you should do on any project is make sure your records of how you intend to do the works are kept. And this is really important because if the employer makes you change your method of working, you have to be able to prove what the original intention was. So records such as method statements, plans, subcontractor supply agreements, procurement agreements should be kept. And then later the as-built records can be used to show why and where you diverted from that process. And so you have as planned program, resources, method statements, man hours of plant, and then as-built records would be your as-built program, your resources used to related to the program, man hours, plant, periods of activity, and then records related to the cause of disruption and delay. So the events have to be proven as well. And then of course, the kind of metrics that you need to identify as part of your records, things such as joints per day, inches per day, piles, meters cubed. These are the issues I've talked about in relation to disruption. And so you have the outputs. The inputs, of course, would be your man hours, your machine man hours, your travel time. These sort of things are absolutely fundamental in terms of proving your case. So that's it from me. I've no doubt that you have seen this this quotation before, but I think I love it. A party to a dispute, particularly if there's an arbitration, will learn 3 lessons, often too late: the importance of records, the importance of records, and the importance of records. It's a quote that has been presented many times, but it's so important, and I can't underline it enough. So that's it from me in terms of my presentation. It's an absolute pleasure speaking to you. Please put some questions in the chat room so that we may answer those questions as part of the Q&A. And I'm delighted to pass over to Sarah, who's going to talk to you about disputes avoidance across the project cycle. Thank you.
Thank you, Ben. And thank you for everyone who has joined today. As Ben also said, we're delighted to be speaking with you today about disputes avoidance strategies. Terry has done a very good job of introducing us, but I thought it might be worth just adding that CMS is an international law firm. We've got more than 70 offices worldwide. I sit in the London office, and the work that I do is solely in the infrastructure, construction, and energy dispute space. And I really focus increasingly on issues for disputes avoidance, in addition to assisting clients to prepare with international arbitration. So let me just take control of these slides. So we've just got some stats there on CMS, which you can go back to later on if you like, and some information about where our offices are located. So I'm going to start with a poll question and give you a little bit of time to respond to this. And so this is, are disputes in the construction sector unavoidable? And if you can click whether you agree or disagree. I'll just give you a little moment to do that. And so if we move on to the results, if I'm doing this correctly. Whoops. So we've got quite a few people who agree or think that disputes are unavoidable, and we've got some people who disagree. And I guess the reason I've asked this question is that I'm hoping, as a result of the discussion today or the presentation today, that for people who think that they are unavoidable, perhaps I will persuade you that there are ways that disputes can be avoided, or claims can be minimised, or the quantum in dispute can be reduced as a result of some practical strategies that I'm going to be speaking to. So last year, CMS conducted a survey and in which we had over 50 senior legal and management personnel responding to a range of questions on disputes, on risk management and disputes avoidance. And just to give you a feel for where these respondents were drawn from, most of them form part of ENR's top 250 global contractors, and it was a pretty international survey. So we had respondents from Europe, Middle East, Asia Pacific, Africa and Latin America. And this survey was really carried out, it was our first survey, and we're planning on doing this every year to take a feel for different issues that contractors are facing and their approach to disputes and the like. But this was really carried out in recognition of the fact that the construction and infrastructure sectors give rise to these long-running and expensive disputes, that we were at that point in the early stage of heightened uncertainty and economic volatility. Ben's already mentioned the C word, COVID, so that was in the early stages of understanding what that meant. And also recognising that all parties to big projects are now increasingly looking for ways to avoid disputes or minimise disputes. So participants or respondents were asked to identify the factors that were most likely to cause conflict in their view. And I think the response here is pretty unsurprising. So primarily people said that it was either cost or time. But I think the encouraging response in relation to whether there was room for improvement on how risks were managed on a project, and I think that naturally leads to avoiding disputes, was overwhelmingly yes for every person who responded to this survey. So what I want to do, I mean, that doesn't tell you very much about how you can manage disputes. So I wanted to move on to drilling down into what parties actually thought they could do to better manage risk. So the first of these is very much aligned with what Ben has been talking about, and this is keeping better records. So I'm going to get into a little bit more detail on this from the tribunal's perspective and talking more about how witness evidence is perceived a little bit later on. But speaking to this here, I think what I wanted to emphasize is that there are two aspects of record keeping in my view which are important. And the first of these is obviously the record keeping itself, but the second of these is document management. On the range of projects that I've been involved in, the worst case scenario is where you have very poor record keeping. And so the difficulty there is you simply don't have the documents, the contemporaneous documents, to support your case, and that can be very problematic. But I would say that that's followed by adequate record keeping where there isn't an adequate document management system in place, and so it can be very difficult to actually identify the documents that you need either quickly or at all. Once a matter gets to arbitration or litigation, and obviously beforehand, there are tools that can be deployed to search for documents, and that includes tools that use artificial intelligence. But actually, I don't think that that's necessarily a good replacement in the early stages of issues arising for being able to quickly identify the documents that you need to understand all of the issues in dispute and what your position might be. And so then obviously the best case scenario is that you've got both good record keeping and a very good document management system or policies in place as to how documents should be named and filed and stored. I would also add here that in arbitration, arbitration can be distinguished from litigation in that you probably would have more onerous disclosure or document production requirements in litigation, whereas in international arbitration, it can feel that it's a little bit lighter and on document production requirements. Although for anyone who's been involved in an international arbitration, I'm sure that they would laugh at me saying that because it can still be quite burdensome. But I think the thing to remember in international arbitration is that you're not necessarily going to be able to obtain documents that you need from the other side. In fact, you shouldn't assume that you will be able to do that at all. And I have seen a number of clauses which, a number of contracts which contain clauses which state that neither party will be able to demand documents or witness evidence from the other side. And obviously, in those circumstances, you are solely confined to the documents that you're able to identify yourself to support your case. So the second of these, which was it came very closely behind keeping better records, was managing change. And this sounds pretty vague on the practicalities, but concrete examples here would include recording and agreeing variations in line with contract requirements. And I would emphasize what Ben has said here, that whilst there might be a desire not always to follow what's required under the contract because it might be seen as being overly assertive or aggressive, I think it's always important to be checking what the contract says and to be managing that in line with the contract. And I'd also say that I think it's far easier to manage change if you're managing it at the time that the change occurs. You will be able to identify what your options are at that stage, whether it's bringing in an expert or carrying out a root cause analysis or taking evidence to substantiate your position. But the further you move away from where that event has occurred, I think the more limited your options become. And so it's important to take action early. The next of the risks that were identified, or areas where there could be improvement, was early identification of risks during the tender phase. One of the things I wanted to comment on here is really just what we're often asked to provide advice upon, and that will be, taking a look at a contract and seeking to and providing a legal merits view in relation to a particular claim or position. And often when we have to do that, or when I do that, I will look at the contract clauses and there will be areas of uncertainty which I identify, and that can lead to uncertainty in the outcome of any formal dispute. But I don't think that you need any particular legal expertise to actually identify those areas of uncertainty. And so my recommendation is, if you have the time or the ability to do this, at the time that the contract is being negotiated, take the particular provisions which will be so important in managing risk, and those are the variation provisions, force majeure, extension of time claims, limitation of liability, and work through them and see if they work and see if you understand how they're meant to work. And where there is uncertainty, I think you have two options. The first of these is to seek to negotiate a clarified amendment with the other side. But I would also recognise that for many clients that I work for, they are simply presented with terms and conditions and told that they can sign that contract or they won't have a contract. And so I still think it's worth identifying these risks in those circumstances, because if you know that the risk exists, you can put a strategy in place to manage that risk going forward. And an example here would be if you're not entirely clear on what needs to be done in respect of a claim being made, for example, an EOT claim, you might decide that you want to do all that might be necessary on like a worst case reading of that clause, so that you can seek to avoid an argument later on that you haven't complied fully with the contract provisions. And the fourth area that was identified was submitting notices. And Ben has done this, and really, it really is so important. The question of whether or not strict compliance with a notice provision under a contract is necessary or acts as a condition precedent will depend very much upon the wording of the contract, and whether that is enforceable will depend upon the governing law. But from an English law perspective, if you have a clearly drafted clause which states that you must give notice within a particular period of time, and if you fail to do that, you lose your right to make that claim, that generally speaking, that type of clause will be enforced. Now, the position won't necessarily be the same if the clause is badly drafted or where the governing law takes a different approach, but the best approach to take from a risk avoidance strategy is to make sure that you comply with notice provisions. So we've got a reasonably limited time left to be talking about keeping of better records, but I wanted to touch a little bit on how record keeping and evidence is used in a dispute, because this ought to, in my view, inform the record keeping process throughout the project. So taking a step back in respect of any claim that ends up in arbitration, and in very simple terms, you need to have a legal basis for asserting your claim, and you also need the evidence which supports the facts that you're relying upon. I think that the point here is that it's a very long and winding road between the event that occurs, which gives rise to the claim, and ending up in formal dispute resolution. And also that there are usually multiple opportunities between the claim arising and formal dispute resolution to engage with your counterparty to seek to settle those claims. And I think you put yourself in the best position to do that if you have solid contemporaneous evidence which supports your position. So I wanted to move to a quote that comes from an English judgment. It's a High Court judgment, and it's on, I'm just going to move to the next slide so you can see this. And really this ought to give you some insight into what a judge would be focusing on when assessing evidence before them. And the reason I'm looking at what a court, an English court judge has said, is because in respect of contracts that are governed by English law, and often another common law system on an international project, it's quite common for arbitrators to be ex-judges or selected from the bar, or sometimes solicitors, and they will often view evidence in the same way that the judge talks about viewing evidence in this case. So this wasn't a construction case, although it involved multiple witnesses, and there was a substantial lag period between when the events occurred and when the case came before the courts. And I just want to draw your attention to some of the points here that come out of this quote. So the judge said, an obvious difficulty which affects allegations and oral evidence based upon recollection of events which occurred several years ago is the unreliability of human memory. And so here we have, I think, real recognition that human memory is fallible. I find the next bolded part interesting, in that the judge has decided that actually little reliance should be placed upon witnesses' recollection of events. And then it's really the final comment here, which is important. It is, above all, it's important to avoid the fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. And in this judgment, the judge basically said, and it's on that basis that I will be assessing the evidence in this case, and really focused on contemporaneous documents or primary documents as opposed to witness evidence. So just going back to my previous slide, and to emphasize that this is something that's become important in the context of international arbitration. There is a report that's recently been published by the ICC. And if you conduct arbitrations under ICC rules, you'll be familiar with what the ICC is, but it's the International Chamber of Commerce. And so this report was prepared to take a look at the accuracy of fact witness memory in international arbitration. And there's just a couple of points I wanted to share with you. The report found that a high level of interaction between a witness and other sources of information can lead to distortions of memory. And the report talks here about post-event information. And so an example would be where you have an event which occurs, and then some years later, when a claim is being prepared, co-workers might discuss it with each other, and then they discuss it with in-house legal, and then they discuss it with external legal, and then they assist in preparing witness evidence. And the report recognised that as a result of all of these stages of looking at the evidence, often there are real opportunities for the witness's memory to be changed and skewed. The report also recognised that witness evidence is used for a range of reasons in proceedings, and not all of them lead to issues with the fallibility of witness evidence. So you will have, for example, witness statements which just tell the story or provide context. And in those circumstances, what a witness recalls is likely to be less important than a disputed fact. The report then went on to set out some measures that can be taken. Now, most of these are for counsel like myself to be thinking about, and for arbitrators to be speaking to each other and thinking about. But there's just a couple that I wanted to land upon because I think it's informative about the importance of record keeping. So the first of these was a recommendation that in-house counsel establish procedures for project teams to keep contemporaneous written or oral notes of issues that are being discussed at the time that the actual event occurs, for witnesses to then be interviewed at the earliest opportunity, and also for witnesses to feel comfortable in distinguishing between what they actually recall, what they have assumed to be the case, and to say, I simply have no recollection of what occurred at that time. There's two final points I wanted to make on this slide. The first is that documents and what constitutes a document is very broad, can be very broad, and parties are often surprised to learn that this can extend to personal emails, WhatsApp messages, text messages, and communications which are often more informal. And it's important to think about that when an event occurs. I have clients who use WhatsApp all the time to communicate on projects, sometimes with the other side, which always gives me nightmares because I think that you lose a lot of what you're saying and can create dangerous documents when you do that. And then a final point is that obviously it's very important to create contemporaneous documents, but you might also want to give thought to dangers that can arise in creating them. And an example which might assist in understanding what I'm talking about is a case that I worked on where a steam turbine blade had liberated from a steam turbine on a power plant, and it led to a very lengthy outage and a claim of force majeure. Now, one party said that it was just something that happened and that they were entitled to claim force majeure, and the other party said that the operator of the plant hadn't behaved reasonably and prudently. And so there was a trawl through old documents, and a report was found that looked at steam chemistry for the operation of the plant. This was highly relevant, and actually it had been conducted without the person or the report writer carrying out a thorough investigation of the steam records, but it didn't give a very good, it was not a glowing report about the way that the operator had overseen the operation of the plant. And it was then shared internally with a lot of swear words and exclamations about how bad this looked and they haven't been doing their job properly. And my point is that it was quite difficult to recover from that subsequently, even though we ended up having an expert on board who was able to say that it wasn't an accurate report and it shouldn't be relied upon or taken into account. So if you're investigating something contemporaneously, it's important to get legal involved, often because what is being produced at the time can attract legal privilege. And if it attracts legal privilege, you can rely upon that to prevent the other side. So it's an important point to just be thinking about. So moving on now to my next poll question, and this is disputes avoidance strategies are most effective if deployed at the beginning of a project or later on once a dispute arises. So please select either at the beginning of a project or once a dispute arises. And so checking what the feel of the room is on this. Just waiting for the results to come up. Right. Well, I'm glad that this has been the outcome, because I think that I would agree with this entirely, or the people who've said at the beginning of the project. And I'd be very interested to talk further with those who think that it's most effective once a dispute arises. I'm very firmly in the camp that it's easily most effective if you're deploying these sorts of strategies at the beginning of a project. So I just wanted to talk to you about the life cycle of the project and the ways that you can minimize disputes across the project life cycle. I'm just having some problems moving the slides. So I'm just going to talk through each of these icons to give you a feel for why I think that there are ways of minimizing conflicts and disputes from the outset. So the first of these is recognition that risk management works best if it commences from the outset of the project and is carried out throughout the life cycle of the project. I think what is key to this is regular contract review. Now, for experienced contractors, this may be par for the course. It's important, in my view, to look at what you were dealing with at the beginning of the project. We often are involved to carry out a kick-off meeting, to identify clauses that might be problematic, and to put in place policies and strategies for dealing with risk across the duration of the project. Another thing that you might want to consider are dispute review boards. Many of you listening today are likely familiar with what a DRB does, but for those of you who aren't, a DRB is very much a creature of contract. So what it does and what it's permitted to do will depend upon what the parties have agreed. But ordinarily it's 3 independent and impartial individuals who are selected by the contracting parties at the commencement of the project. And the idea is that they're involved for the life of the project in assisting with dispute resolution. Now, that can range from them assisting the parties with informal dispute resolution to making a decision which might be binding, except for if it's referred to arbitration. And really, DRBs can be quite helpful because you've got people who are involved in the project, they understand what's happening day to day, and they have a feel for what is going on. And so it can assist with rapid resolution of issues. On compromise, I mean, I probably don't need to say too much about the importance of compromise when I'm speaking to a Japanese or largely Japanese audience. I think one of the points that Ben had made earlier about cultural attitudes and, for example, not wishing to put in a notice because of how it might be viewed. I've often seen disputes arise where there's been a real gap between the parties who come from very different cultural backgrounds. And I mean, it might be helpful to know here that statistics are often published about countries that are the most litigious and the least litigious. And Japan definitely doesn't feature in the most litigious. And you're looking there at countries such as Germany, Sweden, Israel, Austria, and the USA, and also the UK. And so you can have parties that are quite happy or feel much more comfortable with proceeding to formal dispute resolution, and those who feel as though that would be an absolute worst case scenario. And that can cause problems with compromising given the different comfort levels. But I think compromise is always something that should be considered. And this really brings me on to alternative dispute resolution. Mediation has fantastic statistics for resolution that's achieved. The last time I looked at some stats that were published by a UK body called CEDA, they reported that 89% of matters that were referred to mediation settled either at mediation or shortly thereafter. And so it's certainly worth considering. So I'm almost at the end, and we'll be speaking on the panel shortly. I really just want to cover off that I would split continuous risk management into 2 areas. The first is regular contract review, and the second is how you deal with incidents. For regular contract review, there are some key things to consider. And I spoke earlier about the provisions that you might want to be absolutely across to make sure that when an issue arises, you know what you need to do. Commonly, variations and force majeure events can give rise to disputes because the provisions aren't properly followed. So it's important to be thinking about those. And then for incidents, I would say it's important to act promptly. So I spoke earlier about the ability to carry out a root cause analysis and to react at the time, because you're likely to have a full range of decisions that you can make at that point, and that will become more restricted as you move forward and further away from the event. The final point I really wanted to say was really about early case assessment. We're often asked to come in and to give a view on the merits of a case and to assist with understanding the issues in dispute. And I think that it's something that the reason I would recommend it really is because it's good to get an independent and impartial view on the merits of your claim and really to understand what the risks are of proceeding to formal dispute resolution. And sometimes that will be that you've got a very strong case and you should push ahead. Other times it might very much give you a reason for wishing to engage early on in dispute resolution with the other side in an informal way, knowing what the potential downsides are of your case. And so this is something that we're often asked to do, and I think that always puts parties in a good position for understanding the issues that they need to deal with. So thank you very much for listening to me, and I'm going to hand back over to Terry now, who is going to conduct the panel discussion.
Thank you, Sarah, and thank you, Ben, both for very interesting presentations. We now have about 20 minutes for our panel discussion, so let's start off with that. Perhaps I could just start with a question for Ben, just picking up on the two presentations. You know, project management was a big theme in both those presentations as needing to be you know, key factor to minimize and avoid disputes. And Ben, I just wondered, and I would like Kunikane-san to comment on this as well, but I thought it'd be useful to have your comments first, Ben. Is in your experience, do you find that there is a direct link between good proactive project management on a project and the minimization of disputes? And if you have noticed that theme in the projects you've been involved in, you know, what would you say are the sorts of good things that comprise proactive project management in order to head off disputes and minimize them?
I think it's a great question, and I think, you know, the answer in some respects is obvious. I mean, good project management is absolutely fundamental, and it's not just about being a kind of procedural administrator of a project, but if you look at the places where modern thinking in project management has sort of found its way into construction contracts, for example, in the UK, where whilst it's not always successful, the idea of collaborative project management, so where really the contractor and the employer and its project manager come together in the management function. So instead of one party sitting at one side of the site office and the other party sitting either in another site office, but actually working you know, in a collaborative way. And I think if you have a project manager who wants to be part of the solution rather than just being an approval roadblock or somebody who's really just got the employer's best financial interests at heart, if they come together and when a problem arises, they deal with the problem at the time with their own suggested solutions, and that includes using their own manpower from a management perspective to help their contractor find a solution. It's I think a really important part of a successful project. And then having joint targets. So instead of having targets which the contractor has to achieve, and then the employer being an approval part of those targets. Instead, the contractor and its project manager have a joint target, and they are both financially rewarded for achieving those targets. And so if they achieve the targets, both the project manager and the contractor gets an award. And if they fail to achieve the targets, you know, both parties are penalized. I think that's a really, you know, important part of it. It's a challenge for project management companies. I work with a number of them, and some of the big organizations, the issue they really have is they recruit by project, and that's a big hurdle for them to overcome. So you can imagine if it's something of the scale of an airport, something of the order of 90% of the project management team will not be in-house employees of the project manager that's been employed. So the challenge for them is to be able to drive down through the culture of their organization this collaborative approach in a circumstance where at any given project, 90% of the staff are new into that culture. Probably pass on to Kunikane-san to comment now, but that's certainly my view.
Yeah, thank you, Ben. Yes, and now Kunikane-san, yes, I'd be interested in your comments about the link between project management and the minimization of disputes. And just given the two presentations we've heard, you know, we can see that, you know, it's important for project managers to be sort of proactive in operating the contract, in knowing the contract well, so that they know which events trigger notices and what they need to do to operate the contract. And also the whole question of keeping on top of correspondence and making sure that you are creating the records and not leaving correspondence unanswered, because as we've heard from, you know, Sarah's presentation, you know, if you are in front of a sort of tribunal, there's so much weight is attributed to documentary evidence written contemporaneously, rather than, you know, what people say 2 or 3 years after the event. So we'd be very interested to hear from a contractor's perspective, you know, whether your experience is that good project management very often leads to the avoidance and minimization of disputes.
Yeah, thank you, Terry. Thank you, Terry. Firstly, I agree that the proactive conduct of the project manager is very important, because as it shows in Sarah's presentation, everyone knows disputes cannot avoidable in the construction projects. So it is important. It's maybe one of the important things to avoid the dispute is at the very beginning of the stage, we read the contract, and not only the conditions, but so reading the specification and carefully, and to know what is a critical issue for the project, such as to raise the main issues, main possible issues, which can be big claims, and for example, if the project involves massive earthwork, so that maybe typical claim is the contractor bought lots of soil, borrow soil from the outside, but the later engineer denies such claims, because the engineer or employer may say the many suitable material is excavated within the site. But the later stage, it is very difficult to prove the volume of the soils after the construction is almost completed. But if we, even in such a case, if we if we carefully read the specification, and if we knows well about the method of statement or the construction sequence of the program, and maybe we can point out which may be critical in this project based on our experiences. And in such a case, maybe we can make a object of the claim, and maybe we can establish the strategy for the claim for in case if we encounter such a problem. And so so by finding or establishing or selecting the important possible claims, maybe we can concentrate and to which kind of records we should keep during the construction. Terry said it may be a problem, or it may be difficult for the contractor to keep the records during the construction. And I think one of the reasons is maybe usually the site engineer sometimes doesn't know very well what kind of records we should keep, or we should correct. And so, but if the site engineer or construction engineer knows or understand which part will be a problem, maybe they can collect appropriate records. For example, so if they are regarding the earthworks, they may gather or keep the records for the volume of the borrow material, or they may keep the records of the unsuitable materials to dispose, or like that. And then we can keep the appropriate records. And another thing is regarding, and maybe the one important conduct for the contractor or project manager as a proactive conduct is to select the claims, or to select the claims at the very beginning, at the very early stage, and to keep the claim and developed continuously, so in order to find the claim which will be important or which will be strong, maybe it is important to ask the outside advisors, such as your lawyers or claim consultants, maybe, and with the assistance of, with the support of is the support of such external advisors, maybe we may select which claim will be stronger, and which claim we should maintain at the end of the project.
Yes, thank you.
So maybe your assistance will be very important, I think.
Yes, no, I agree, and thank you for those responses. That's very interesting, and I totally agree. I think it's very important for contractors to be proactive in the sense of deal with the claims head on at the time, because there is often a temptation to sweep claims aside and leave them till the final account and then deal with them right at the end of the project, which I think is a way of encouraging disputes to grow and escalate into unresolvable disputes. And I think it's very important to deal with them contemporaneously. And you know, as Sarah touched on, to carry out a sort of thorough factual analysis where necessary, get some technical input and do the legal analysis and evaluate the claim contemporaneously, so that you can then put yourself in a stronger position for any sort of negotiation. We've got a few questions and we've got sort of limited time, but maybe we'll just, there's time for just one more question. And I'll turn to Sarah for this. And it's a general question about force majeure. And we have had recent events in Myanmar with a military coup, and such political events are not unusual in other countries. And Sarah, I just wondered, in response to that question, whether you thought, typically, I know it depends on the form of contract one is under, but typically would that sort of event be a force majeure event under a fitted contract? And have you got any advice for parties embarking on contracts on what steps they might take to protect themselves against such force majeure events in other countries?
Thank you, Terry. It's a really good question, because I think we are in an age where there is increased uncertainty. If you're working in international or in locations where there are high risks, then there are likely to be events which might be claimable as force majeure. And so I think the things that a party ought to be thinking about, first and foremost, is that under English law, force majeure is, it's not a term of art, it's a creature of contract. And what I mean by that is that if you didn't have a force majeure provision in your contract, you wouldn't be entitled under English law to claim relief based upon force majeure. So in order to claim it, and also in order to understand what protection is given, you have to look to the terms of your contract. The other thing that I would add is that I very frequently see claims being made of force majeure where either something has happened, and COVID is a good example of this, where you might initially think, well, that must have caused some disruption, but in fact it hasn't caused any disruption at all. Or there might be some delay, as an example, but it might be part of that might be attributed to the claim force majeure, and part might be attributed to other causes. I think the key things really to be thinking about is that, in addition to looking at the terms of the contract, ordinarily force majeure requires that the event prevents a party from performing its obligations. And so if it's really just harder for you to do what you're required to do under the contract, or if it's more expensive, that ordinarily would not constitute a force majeure event. And the final thing I would say is, this is harking back to what we've spoken about quite a bit today, but it's the importance of record keeping and notice provisions. So many force majeure clauses that I've seen will have the notice requirement operating as a condition precedent to claiming force majeure. And equally, I've seen force majeure being claimed, and then some years later, when the claim finally makes its way to an arbitral hearing, there being insufficient evidence to support that claim. So the best time for keeping records is at the time that the event occurs. Specifically in relation to Myanmar, I think that the state of emergency that's been declared and the follow-on events could well give rise to force majeure being claimed. But the ever important point is to look at the terms of your contract, think realistically about whether it's actually preventing you from performing. And I would say as well, in order to avoid the risk of a formal dispute, you really need to engage with your counterparty and seek to mitigate the issues that are arising. That's probably the best way to avoid ending up in a full-blown dispute.
Thank you very much. Well, we have almost come to the end of our allotted time now. There are one or two more questions that we haven't had time to answer, but we will do our best to answer those by email. But I think to wrap up, I think what the key messages that have come out of today's presentation are that good project management is one of the key factors to minimizing and avoiding disputes, and being proactive in your project management puts you in a good position to head off future disputes. It's important to know your contract well and operate it if you're the contractor seeking to get the best out of your contract. Very important to evaluate your claims early on and contemporaneously, and that often means seeking independent advice and getting on board either legal or technical advice if that is necessary, to give you an objective view of the strength of your claim, so that you will have greater confidence in setting your objectives on how you want to settle that claim and how you might advance it. And lastly, I think somewhat surprising for a lawyer to be saying this, but it's far better to settle your claims early and compromise them early than to win in litigation many years later. So I think that brings us to the end of our hour and a half, and just a couple of housekeeping points to end. You will all receive a slide pack at the end of this webinar. I understand there will also be a recording available that you will have access to. And as I say, I think there are a couple of questions we've not had a chance to answer. We will seek to answer those by email. But if any of you have any follow-up questions, please do email any of the panelists who will be delighted to answer your question. So that's all from us. Thank you for participating. Thank you for listening. Good evening. Goodbye.
Thank you.
Thank you.
Thank you for having me.